Paul?
I'm going to have my co-chair here, Henry Kelly, to talk about this issue.
Thanks, Paul. This particular issue was viewed by this committee, subcommittee, as a significant issue in the private sector around employers who could be subject to liability for failing to exercise ordinary care in hiring and retaining employees, most notably known as negligent hiring. Because of this, we looked and had folks to talk to us about what some of the other states have done to help companies feel comfortable that they could have the ability to deal with this concept of negligent hiring. So the recommendation to this committee is that we create a rebuttable presumption for employers in a negligent hiring or negligent retention suit to protect employers from liabilities for acts of employees by having particular inmate or person who is now out of this, being let out of the system, to be able to attain a certificate of rehabilitation and fitness for employment from the Department of Corrections. So this becomes a certificate that's issued by the department that the employer could use as his evidence that, quote unquote, this person has done all the things that they need to do to be considered rehabilitated. 2 states have passed similar, has approved similar action, North Carolina and the state of Ohio. So that is our recommendation.
Henry, if I recall the reentry committee's discussions, it seems like our recommendation will probably look more like the North Carolina statute than the Ohio statute, if that's correct.
That's true.
Okay. And I think that this is another important time to comment on the fact that consensus on a bipartisan, interbranch, geographically diverse council like this requires balance and compromise. And I think that, you know, some states, Ohio and North Carolina were mentioned because they're the states that have done the rebuttable presumption. Some states, actually a good deal of states, have done a complete bar against negligent hiring, and that's probably, in my opinion, too much of a step, especially in terms of you know, a plaintiff's right to go after what may be a true mistake by an employer. So I think that creating a rebuttable presumption provides for the right amount of balance, in that there is some legal incentive for the employers here, but it's not an incentive that cannot be overcome in a courtroom. Helen? Or Katie Jo?
This is just a question. If any discussion was had around the Department of Corrections liability for the certificate program, because I don't want any issues to fall on the Department of Corrections when they issue these certificates either.
I think the Department of Corrections, you know, we did some background check, you know, ran this by them, and they're already issuing certificates for completion of vocational training and some other items. Greg, please stand up, correct me if I'm wrong. But y'all are already completing or issuing certificates for completion of, you know, certain things. We don't know if it would be called a certificate of employability. In North Carolina, it's called certificate of relief. We'd certainly defer to the department on how to implement this and execute this recommendation. But I don't think that them issuing a statement that say, you know, they completed their residential substance abuse treatment or whatever else it would be to for the department and the legislature to determine that they would be employable, that's not that far out of what we're already doing. Is that correct, Commissioner?
I agree, Thomas, and we do a lot of certificates already, and as we look at this, we'd be looking at a certificate of completion of a reentry plan. Is what we'd be looking at.
And then we've even discussed with, this could be a good thing to use as conditions of probation or parole as well.
Yes.
Paul, or sorry, Sheriff was first.
That was my concern. I appreciate that's a lot of water for the Department of Corrections to tote. And I just, I appreciate you saying that your input's valuable to this whole commission, and that was important for me to hear from you. Thank you.
Is that Ms. Roseberg?
Yes, it is. I support this proposal, but I do have concerns about making it a rebuttable presumption as opposed to completely barring the action. If we make it a rebuttable presumption, then we're saying that there are circumstances in which an employer could hire someone, determine that they have the certificate and otherwise have the qualifications for the job, but somehow otherwise done something that we would consider negligent as part of the process. So we would be saying it's only a rebuttable presumption because you can be negligent even if you go through the steps we're asking you to go through. The person has obtained the certificate, you've followed your other hiring processes and procedures, but you were somehow still negligent. I think that making it a rebuttable presumption means that it's more difficult to get summary judgment, more difficult to get actions dismissed, and therefore not very much encouragement to an employer to accept the authority that we intend the certificate to convey.
Ms. Roseberg, do you think that that could be perhaps rectified by considering making it a complete bar so long as the requirements are very explicitly spelled out on the text of the statute?
Requirements in terms
Requirements to achieve that bar. Because I think the idea behind rebuttable presumption is that, even if an offender had this certificate from the Department of Corrections and the employer knows of that certificate, there still could be circumstances by which the employer may be negligent. So if we want to discuss a complete bar, is the balance adding more requirements for the employer than just knowledge of the certificate?
I would say if our goal is to make it so that liability cannot be based on the conduct that's covered by the certificate, that should be a complete bar. If you're concerned about what the employee's subsequent behavior might be and not allowing the certificate to become a bar to an action that might be based on a subsequent retention decision after some other behavior by the employer, then I think that's valid, that you wouldn't want but there can't be piling on, right? So the certificate as to what it covers should be a complete bar, but recognize that it has a limit to what it's intended to cover.
Paul?
I think that what the committee was trying to get at here is that there may be other things that the employer has done that would be considered negligent hiring, but that I sort of think of it as a trial situation when the case comes before the court, that the criminal record of the employee involved would not be a part of the evidence presented, but there could be other evidence presented about how this employer was negligent in hiring, and some of that may relate to the negligent act the employee actually committed and what did they do. So it's just that the criminal background here, we're trying to give some protection from the liability that may come from hiring somebody that has a criminal record. I did have, one other comment about this certificate has some potential, I think, for the future for us to look at maybe again in areas other than just employment, because there are other applications that could be made, especially in the area of housing, where an agency is denying someone a housing or a lease of housing, and they may be more comfortable if somebody has a certificate of rehabilitation. We just haven't had time to explore that particular part of it, but this certificate could be very useful potentially in some other areas as well.
Ms. Roseborough?
Yeah, my thought is that if we want the certificate of reentry to have value in terms of making someone more employable than they are without it, if the only thing that the employer is getting with respect to an employee that has the certificate is the opportunity for, to defend yourself on positive and standard, you really haven't extended anything that's going, you're still, the litigation risk remains identical as far as the employer is concerned, because the litigation risk is not bound up in the ultimate outcome of the case as much as it is being dragged into the litigation process with respect to the employee, and that remains the same. So unless it includes a way to say, with respect to what's covered by the certificate, whatever that is, that a claim of negligence can't be based on the conduct or for hiring someone with the background that's covered by the certificate, then I think that's where we want to draw the line. If it's based on retention because of subsequent behavior by the employee, that's fine, but not with respect to the conduct that's intended to be covered by the certificate.
JP?
Thank you, Thomas. I think it's important to point out, because I was educated by this. I think a lot of this depends how it's taken by looking at the merit of the certificate itself. You've got to have the employer buy-in. You've got to have the public's buy-in on this certification, on this, this document. But the Department of Corrections is not, they're not just a housing institution that holds inmates till they're ready for release. To be honest with you, that was my impression. But after working with the DOC, with this council like I have, I mean, they are geared heavily towards a rehabilitative resource for the state in their current operations, and they're taking more steps to get even further. So I think this is an ongoing process, that the more attention that they put into it, the more effort they put into it, the more merit that this certification has, the more buy-in you have from employers and the public, at which point, at that point you've got it to where the certification has due merit, and it carries a lot of weight with it. In respect to the to the protection of the employers that utilize it, in my opinion, a lot of that's give and take. You've got to have a little bit of breathing room in order to get it in place. You've got to have a little bit of experience and runtime with it. Now, granted, there's some risk with that, but still the ultimate goal is the benefit of everybody.
Right.
So,
and I think to Ms. Roseborough's point, I think that if an employer's litigation risk is remaining identical, that's hard to get employers back.
sure.
Right. So I would recommend us wordsmithing 2 recommendations on this for further discussion at the next council meeting. We'll draft one recommendation reflecting Ms. Roseborough's point that with the respect to what's precisely covered by the certificate issued by the department, that would be a complete bar to a negligent hiring suit. And with respect to any other potential negligence on the part of the employer, that it would have no effect on a negligent suit there. And then we'll also wordsmith a recommendation that includes the rebuttable presumption, and we'll continue this conversation and pick one to vote for, if that sounds agreeable to the council.
So moved.
Second.
Judge Steele, did you have something to add?
My only question would be, in order for us to make a good decision, I think the Department of Corrections got to give us sort of an idea of what they're going to certify.
Right.
If it's, for instance, I think employers still have to use common sense.
Right.
And if the certification is, this is a person who has gone through drug rehabilitation treatment, they were convicted of drug possession, and they've gone through drug rehabilitation, that's really not relevant to whether they ought to be able to be employed at Sears working as a cashier at Sears.
Right.
I do have a concern if the person was convicted of stalking and peeping Tom, and correction says, well, we certify they've gone through the classes that are required here in corrections, and we certify they've got their GED, they've done these things, and then the apartment complex hires them to be the sole night maintenance man at the apartment complex, I don't know that we want to tell the public that that's a complete bar, that they're barred from suing when one person engages in those activities. I think we need to say, employers still got to use some common sense of, is it an appropriate employment for that person?
Greg and Stan, could y'all pull together some information on that, at least some, high-level information that we can distribute to the council for their reading enjoyment over the holidays?
We have to do, Thomas,
Nice.
and a lot of it will be on the reentry plan around that offender, and then obviously as you guys work through how that would work, Judge, you have to determine that level that you just mentioned. But a reentry plan and completion of it is exactly that. It's an assessment of their risk and needs, and they've completed it. But obviously there's some concerns, just as you mentioned, based on that specific position.
Well, and I assume, sort of going back to what Katie Jo said originally, I mean, your certification is basically going to be, they have done these things. Their behavior has comported with these requirements. They've done these things. You're not guaranteeing anybody's rehabilitated because none of us know what's in the person's heart.
Yes, sir.
All you can say is that they've done these things, because later, if there is a suit, corrections is going to be able to say, look, you can't sue us because we said they did these things. We got the proof that they did these things.
Yes, sir, and we'll have to dig in a little deeper in the North Carolina plan, but what I would envision right now is the completion of a risk needs plan, saying that they have actually taken steps to get them prepared for reentering society and done what they need to do as a framework, but obviously they've got to continue that.
Sheriff?
Just hopefully this will be the final word, but thank you for recognizing me. I want to tell the people here in this commission that my brother was sentenced to 45 years in Hall County, Georgia, not by Judge Dale. He's sentenced 45 years, served 15. There's some jobs he shouldn't have when he gets out, when he's 60-something years old. I'm just going to be direct with you as I can be. And that's why I value your comments about getting the Department of Corrections in, what they'll certify and what they won't, because I'll tell you what, there's some things my brother should not do when he gets out of penitentiary. And to give blanket immunity for something is not going to suit me. Working with your framework and Judge Dale's comments. Thank you, Tom.
I think what it sounds to me like is the productive thing to do is to develop 2 recommendations to reflect the conversation of the council today, and then take the information from the Department of Corrections that you're going to get to us as soon as you can, and then use that information to further this discussion, and then make a more educated decision on the recommendation there. So is that plan agreeable to everybody on the council? Okay.